Yeah, that's fine. That's fine. So I don't have a microphone. I'll try and keep my voice up, but if you can't hear me, you're going to have to cuddle in here a little bit. So first I'd like to explain why I'm here. I'm here, my goal is not to be critical of any current proposed legislation. I'm not here to undermine anyone's attempts at what has been proposed in this legislation. What I'd like to do, if it's all right with you, I'd like to take about 10 minutes of your time and discuss the bill. I just want to share information with you about what's in the bill. And then after that, I'll take any questions that you have. If you're interested in my opinion about some of the aspects of the bill, I'm happy to share that with you. But that's really not my goal here today. My goal here is to share information with you so that you know what's going on up in Albany. So in case anyone's not aware of it, the folks up in Albany are a little bit busy right about now. There's a lot going on. They're trying to get a budget passed. There's some things that you folks in the press have been covering that are first and foremost in a lot of people's minds. There's a big education bill. There's a lot of information and concern about funding of education. There's a grand jury reform bill that's being discussed right now. There are a lot of things that Albany has to deal with in a very short period of time. But tucked into all of these other important issues is a really transforming proposal regarding the criminal justice system, and that's being referred to as the Juvenile Justice Act. This bill is not a standalone bill. It's a bill that's put into the budget. So the time frame to deal with this particular proposal is a very short time frame, frankly, within a couple of weeks. And my concern has been that there are not a lot of people that seem to understand the details in the bill and what I personally feel is the magnitude of the change that this would that would happen if this bill is passed. This is my business. This is what I do. I didn't know a lot of the detail in the bill. When I talk to people in law enforcement who are here with us this morning and people in my office, when I talk to people on the street, no one has any idea about the details in this bill. And that's troubling to me. And I think that something of this magnitude should have more transparency. So thank you for coming and showing an interest. The bill itself, the bill that's been proposed by the governor, is about 160 pages long, 166, I guess. It's very, very comprehensive. And in order to really understand what's being proposed in the bill, you need to be familiar with the Family Court Act, the penal law, the criminal procedure law, and corrections law. And I'll give you just a little example. I don't know if you'll find this humorous, I did, about the language in the bill. So I'll just read directly from the governor's bill one provision, section 23. Paragraph A of subdivision 1 and paragraphs F and H of subdivision 2 of section 353.2 of the Family Court Act, paragraph A of subdivision 1, as added by chapter 920 of the laws of 1982, paragraphs F and H of subdivision 2, as amended by chapter 124 of the laws of 1993, are amended to read as follows. That's the bill. That's the kind of things that are being presented to folks up there to pass on. And bear in mind that some of the folks that are going to be deciding this bill have been in office for about 2 months. And on top of all of the other issues that they have, it's, in my judgment, it's a lot to ask for our representatives to come to grips with some of the detail in this bill. I want to make something very, very clear. I'm not here on behalf of anyone else. I don't have the authority, nor do I wish to speak for the District Attorneys Association of New York State. I don't speak on behalf of any the Police Chiefs Association, which I'm a member of. I'm not really speaking on behalf of anyone. If I offer you some opinions, those are my opinions as the District Attorney of Ulster County. I have no authority, nor do I wish to try to persuade you that my views are those that are shared by other people. So what's this bill about? At the core of this bill is the observation that young people, 16 and 17 years old, make mistakes. There's a lot of science being offered that that at age 16 and 17 our brains aren't fully developed, that actually our brains aren't fully developed till age 24. I'm not a scientist, but I'd say you might push that number up a little bit, but neither here nor there. So at the core of this bill is that young people make mistakes. And because young people are prone to make mistakes, they should not be treated as adults in the criminal justice system, number one. And number two, if they are to be treated as adults and incarcerated, they should not be incarcerated with adult offenders. So you shouldn't take a 16-year-old or a 17-year-old offender and put them in a facility where there are adult criminals, murderers, rapists, and things like that. Okay? And I will tell you that, and I'll get to my opinion about the bill later on, there's a lot to like in this bill. There's a lot of intelligent thought in this process. There's an awful lot of this bill that makes sense to me, and we'll talk about that. But there's some things that are in the bill that I'm not sure everyone is aware of. In its broadest sense, this bill addresses the same type of conflict that we all address every day and what the criminal justice system has been addressing for many, many, many years, decades, centuries, which is the conflict between what's best for the individual and what's best for society. The Family Court Act is driven by the process, the legal obligation to address what's in the best interest of the child. That's what the family court is here to do. The criminal justice system also tries to address what's in the best interest of the individual, but we also take into account some other considerations, such as the victim. What's in the best interest of the victim? How do we protect the victim? Such as society. What's important to protect all of us in society? And what do we do to maintain integrity in the system so that people that live in our society that we are sworn to protect will believe in the system and have faith in the system? So the penal law system and the family court system are actually two different systems with some overlays. The bill proposes to phase in the change in responsibility, penal law responsibility. In 2017, age 16-year-old youths will then be treated in the family court system, not the penal law system, and at age, in 2018, that'll be pushed to 18. So they phase in over the course of a couple of years the increase in age of criminal responsibility. They expand the family court jurisdiction not only by age but also by the type of crime that is committed. So the certain crimes are excluded from this bill. I shouldn't say excluded from the bill, but are dealt with differently in the bill, which I'll talk to you about in a second. But this bill anticipates that all misdemeanors, most felonies, and all violations, and the violations are important to the district attorney because the violations are, like a harassment is usually the genesis of a domestic violence incident. And so all of those matters will now be handled in the family court. And they'll also, they seek to create a youth court, a designated youth court for 16 and 17-year-old offenders. There's some details I'm not sure about, and I don't know, Mel, if you know, you pipe in. Is that a non-jury court? The youth court? Yeah, I don't know either. Yeah, okay. So that it is, my anticipation is that if they create a youth court for 16 and 17-year-old offenders, excluding certain types of crime, that will be a non-jury process with a designated, trained judge that handles that part of the court. Effective this year, at the end of this year, all youths who are going to be detained or incarcerated must be sent to a office, the OCFS approved detention facility. That's that's kind of the big picture of the bill. I want to talk about some of the details. And before I go on to some of the details, I point out that there are some fiscal issues. There's always fiscal issues when you talk about changing things that come out of Albany. I'm really not here to talk about the dollars and cents. It's not my goal. There's people that are a lot more knowledgeable about these things than I am that they will deal with that. But I'll make this observation because it deals with money, but it also deals with some other issues. Generally, the numbers we're talking about in 2014, throughout all of New York State, about 100 16-year-olds went to prison, about 100. And so we're going to have a law at the end of this year that says that 16 and 17-year-old, well, I don't know if it's 16 and 17 or just 16, but these youths will now be transferred into an OCFS facility. I'm not sure where those facilities will be. I know that they don't currently exist. There are some throughout the state. And one of the goals that we have in a situation like that is if you have a youth that is offended in Buffalo, you don't want to have a facility in Rikers Island because his family won't be able to get there. So I think that if you look at the details in a bill like this, you have to anticipate the creation of some brick and mortar issues that I don't know if the finances are going to be addressed. But again, I'd like to put that aside and talk about some of the law enforcement issues that I have with the bill. Another number which I think is important, because the proponents of the bill have been making a lot of comments, which I don't know if they're taken out of context. The comments we're hearing is that, New York State is the only state outside of one other state, might be North Carolina or something, that prosecutes 16-year-olds. And New York State this and New York State that. Let me assure you that every state in this nation deals with offenders of every age, whether you're 16 or 17. And the difference in the different states is, I'm going to borrow a term from another DA, it's the portal, it's the entry into the system. So in some states, the entry into the system may be through a different court, a family court, as opposed to an adult court. But every state obviously deals with young people who commit violent offenses. We are obviously not the only state to do that. And just let me offer you some numbers as a backdrop to this process. And these are the numbers that I don't have personal knowledge of this, of course. This is numbers that I get from the people proposing this legislation. Of all of the youths, of all of the 16 and 17-year-old youths that were prosecuted last year for any adult offense, that means misdemeanors or felonies, 95% of all of the youths that were prosecuted last year did not end up with a criminal record. That means that 95% of the people that came into the system got the charges dismissed or conditionally dismissed or were given interim probation, and their records were sealed with a youthful offender. So I understand the genesis behind this bill and the concern, but I don't want the public to perceive that we are somehow Neanderthal in how we deal with the youths here in New York. So what are these new procedures? Right now, let's say we have Junior is a problem. Junior won't go to school. He's 14 years old. His mom and dad don't have any control. They're concerned that he's going in the wrong direction, and they can't get control of him. So what do? They file something called the PINS petition. And the PINS petition goes to a probation officer. Now, the probation officer does a risk assessment, which thank you, Trish, it was I had never read it. It's good to educate old people. It's a really good form. It's a really good risk assessment form, and it goes through all of the needs that the child has and where, do you have mental health problems? Are there problems at home? Do you have substance abuse problems? And they try and deal with that young man in an appropriate fashion. And they do something called an adjustment. Okay? And the adjustment is mandated by the court, And the adjustment is that the probation officer will deal with this young fella that's got some problems, rather than put the young man in front of a judge. So they are obligated by law to try and deal with that situation, rather than go through the court system. Okay? And not that it matters, but in my own opinion, that makes a lot of sense. It makes a lot of sense that that's how we deal with a PINS petition. This new statute would propose that 16 and 17-year-old youths who commit felonies and misdemeanors would go through the same process, where they go to the probation department, and the probation department's goal would be to adjust the process rather than put the case in front of a judge. And there are a couple things that I think are missing from that process. Number one, the DA is missing. You would expect me to say that, but that's my job. My job is to be in charge of the prosecution of crime in this community, and I think I should be part of that process. So in this new procedure, I would not be a part of that process. Nor is a judge a part of that process. There's no judicial review of that matter unless certain things happen. And so I don't want to overstate my case, but there are some situations where a petition would be filed, there's some that it would not be filed. And the other thing that is not mandated, although I'm sure here, and I've talked to Trish, and she assures me that they do that, and I am sure they do it, because we're pretty good here in Ulster County. But this process does not mandate a review with the victim. So if you have a victim case, and this statute is passed, these cases will now be able to go to a probation officer who has the authority to adjust the case without filing a petition in court. And so there's a whole class of felonies that have a different procedure, and these different class of felonies, this particular class of felonies, are all the things that you and I would be concerned about. You know, murder and rape in the first degree, and gun charges and robbery. None of those things would now be, the statute doesn't provide that those matters would go to probation. Those matters are handled differently because of the severity of the charge. But not included in some of those very serious charges are misdemeanor sex offenses, are drug sales, or domestic violence related matters. So, how many of you watched the movie Groundhog Day? Pretty funny movie, right? It's the one Bill Murray, and he has something goes through his life, and then I don't know, he goes to sleep, wakes up, and he goes through the same thing again. Okay. So this bill has a lot of the goal in this bill is to address the needs of the young person that's committed a crime, and not send them forth with an albatross around their neck. They don't want to have a criminal history. We want to try and deal with the case without having any findings and sealing of records and a lot of those things. And they have a lot of language that I'm simply not equipped to talk about specifically today, but a lot of language that deals with sealing of records and protecting the youth and going forward. And then there's provisions in the bill that says, but you know, if you keep coming back, we're not going to give you some of these considerations. That makes sense. The problem is that unless this offender has the bad luck of going back into the same probation department and dealing with the same probation officer, the prior instances are all sealed. So you are, to some extent, you are forever a first offender. Another portion of the bill which is, to me, well, I won't go into my feelings on it, but just so you know, another portion of the bill seeks to expand youthful offender adjudications to age 21. That means that up until age 21, right now it's to age 19. So if this bill is passed, then in the future, your 20-year-old, let's say, sex offender can have their record sealed. The issue with youthful offender adjudication is twofold. Number one, sex offenders are not, a youthful offender adjudication is not a sex offense finding, and therefore you are not registered under SORA. They're also, you're not obligated, I don't know if it's a specific part of the youthful offender adjudication of the bill, but the authorities are not allowed to take a DNA sample from a person who is adjudicated a YO, which these are changes in some of the other trends that law enforcement has been dealing with. Another provision of the bill, which I find is very interesting, and I've thought about it many, many times, there's a record expungement part of the bill, which I find is pretty interesting. And the theory there is, let's say that you're, whether you're 18 years old or a little bit older, does it go to 19? Well, we'll stay with 18. So you're 18 years old and you do something stupid, you make a mistake, and you get a criminal record. If you go a period of time and you don't do anything wrong, you have a right to go in and have that record expunged. Now, there's some people that say we want to know if somebody has a problem in their past, and there's some people who think it's a good idea. I'm not weighing in on it's a good idea or not, but it's something that's been discussed. It's available in a lot of other states, and it's part of the bill. So that both misdemeanors and felonies with different periods of time that you go through these certain criteria, you have the ability to then have your record expunged. The last portion of the information I want to share with you has to do with this new sentencing structure for these certain designated felonies that are dealt with differently in the bill. Currently, the penal law, Section 70, deals with the mandatory sentencing on different types of crimes. In this particular discussion, it has to do with violent felony offenses. And there is a change in by this statute, the change in the sentencings that are available for these different crimes. And it is a dramatic change, So, for instance, your Class B violent felony offenses, which would be rape in the first degree and robbery in the first degree, burglary in the first degree, manslaughter, things like that. The new sentencing structure would provide for a sentence of between 1 and 7 years. So it's possible to commit those offenses and receive a 1-year sentence. Not suggesting it will happen or won't happen, I'm just saying that's what's in the statute. That's the B felonies. On the Class C felonies, it goes from 1 to 5 years, and C, I think it's 1 to 3. But you get the gist of the change in the sentencing structure. So that's the overview of the bill. I assume that all of you knew all of those details, right? And so at this point, what I'd like to do is open up the floor to questions. And if there are people in this room that know that I've made a mistake in this presentation, please correct it. It's not my goal to make any misinformation. I will be the first to say that this is a complicated bill, and there have been already some amendments, so I hope I gave you accurate information. I believe I did. So I'll open up the floor. Yep.
Do you have an overall opinion about this bill right now? The way it is right now, from everything that you've seen?
There's a lot of stuff I like in the bill. I really do. I am actually very amenable to the idea of raising the age of criminal responsibility for 16-year-olds. I kind of do that now. I mean, you know, in my job right now, as is evidenced by the statistics, and Mel gave me statistics for actually just Ulster County. If I remember correctly, we have about 3.5, under 4% of the people in that age group in Ulster County that are charged with misdemeanors end up with a conviction. So, you know, that 95% holds true in Ulster County. It's not our goal to take a young person and harness them with a criminal history. It's not our goal to take young people that I think have made a mistake and do something that would harm their future. It's not what we do. So if you want to pass a statute that would mandate what I already do, I'm okay with that. All right, I'm okay with that. There's really a lot to like about the statute. I'm intrigued by the expungement portion of it. I think that's an interesting idea, one I've had before. I'm not sure where I weigh in it, but I'm intrigued by it. But there's some portions of the bill that I don't support, and the reduced sentencing is a problem for me. I just don't like the idea of probation dealing with what I think I've been hired to do. I think that if you have a 16 or 17-year-old person who's charged with a crime, that should be handled by the district attorney's office. I'm not sure the result will be any different, but I think that that's something I should be part of the equation. There's a provision in the bill that deals with when a youth is arrested. And they've made it virtually impossible to take a statement from a 16 or a 17-year-old who's been arrested if the provisions in this bill are passed. And that's really a problem for me for a number of reasons. One of the first of all, every person that gets arrested isn't guilty. So the best thing we can do if a person gets arrested is sit down and say, what's up? And they may be able to say, you got the wrong person here. I was with my friends over, at the sock hop, and I didn't do this. And that gives us an idea to go to the right people and get it right, as opposed to detain this person based on information that doesn't hold out to be true. So the ability to talk to a person is critically important at that stage to get us going in the right direction. If a person, and I recognize that sometimes you talk to young people and they admit a crime, and that admission is something that gets them in hot water. But when you're in my office, people come in and say, yeah, we talked to the guy, he admitted what he did. He understood what he did was wrong, he admitted, he apologized. That is the biggest factor in how to deal with the case, whether we reduce the case, whether we even prosecute it, and what happens with sentencing. And so this bill, I know they're trying to protect young people, but that bill actually is hurting them. And I would never be in favor of that. The youthful offender, the extension of the youthful offender, there's a lot of ironies, a lot of ironies in life. I'm up in Albany, I'm chatting with some folks trying to figure out what's going on with this thing. I think it was Monday morning. Monday afternoon, there's a press conference about how the governor wants to go out, and I shouldn't say the governor, the state wants to change the problems that we have on campus with sexual assaults. A huge problem that we have. And he came out in favor of some changes that we're going to make the campuses safer. Who could fault that? Okay? But while he's doing that in the afternoon, in the morning, I'm talking to the guys about extending youthful offender treatment for those offenders, for those 20-year-old people who are committing those crimes on the campus will now have their records sealed. They will not be subject to DNA or subject to a SORA registration. Now, to me, that's inconsistent. This legislature, since I've been the DA, has done wonderful things, truly wonderful things in the battle that we have on domestic violence. They have given us tools to fight domestic violence that we never had before. They gave us a strangulation statute. They gave us a stalking statute. They gave us an expanded definition of families. They really got the program on domestic violence and allowing the people that we work with to go out and combat domestic violence. This statute is a huge step back for the victims of domestic violence. They basically are just not, they no longer have the rights and the input into the system that they have today. And so I can't support that. I would love, honestly, I would love to stand up with the legislature or the governor, whoever is going to propose a bill that's going to make us safer. The idea is that if we can get services to young people, then they won't commit more crimes. The idea is that this goal, this bill, will reduce recidivism. I'm all on, I'm in on that. I'm all in on that. So the idea of taking money and giving probation more services and putting family court, services for family court, and providing these different services so we can prevent recidivism, great. That's great. But the bill has gone too far. The pendulum has swung too far into the area where I think that we are taking away protections that we now have. Question?
What are you suggesting done?
Well, the first thing I would do, no one is going to give me this authority, I would table the bill. Apparently there's some money available to start to get some of these things in place. Let's take that money before they spend it on something else, put it in the budget, and earmark it for this increasing the age of criminal responsibility. And then let's sit down and talk intelligently about what portions of this bill are really good and can go forward, and which portions of the bill perhaps we pull back from. This doesn't have to be a jump off the cliff all in thing. You know, we could start with a portion of the bill. For instance, misdemeanors. We could start with a portion of the bill and say, starting in 2017, every 16-year-old who's charged with a misdemeanor will now go to the probation department and go through the family court process. And let's see how that works. I would be in favor of that. I would not be, well, mostly in favor of it. My own personal opinion is that sex crimes, whether they're misdemeanors or not, that's Article 130 crimes, the sale of heroin and domestic violence, those cases should never go through the family court process without the district attorney's approval. Bear in mind that these are jurisdictional steps. It doesn't determine the outcome of the case. If you change the provision in the bill and say, we have this service available now, we can take these cases into family court, I can take a look at it and say, you know what, family court can do a better job with this case than I can. This case doesn't belong in a criminal court. Let me refer it to family court. I think that's a great idea. And you know what? Once I saw it worked, I'd use it. And I think the DAs around the state would use it as well. This bill does some things that I know is unintended. If you take away the criminal responsibility for a 17-year-old, what do you think every criminal enterprise that involves the sale of drugs is going to do? They're going to recruit a 17-year-old. That's simple, right? So now, and if you couple that fact, and that's a fact, couple that fact with they're going to recruit 17-year-olds to do the handoff, and we pick up the kid who did that, we can't talk to him, and we can't then get to the guy that recruited him. Now, I'm not in favor of that, actually, so I would change that. I would take a little bit slower path on this and have more input. That's what I would do.
Run this by the DAs when it was in committee?
Again?
They run this bill past the district attorneys?
I'm glad you asked that question. Politics. This is not a new idea. This just didn't pop up. For the last couple of years, they've been discussing the raise of age. And the difficulty that we've had is that this is the first comprehensive plan. There have been some edicts from the chief judge, and there have been some other comments that we're just going to change this without really following through on all of the details. This bill did that. This bill came out 2 weeks ago. It literally came out. It's in the budget. It's not a freestanding bill. It's passed it in 2 weeks. There were two DAs on the panel that discussed this. The DA in Manhattan, Cy Vance, and the DA in Westchester, Janet? These are two of the most powerful district attorneys in the state and perhaps in the nation. Really, really high-end people. And they were part of this discussion. But I'm not sure, I don't know if they had all the details. I suspect they did. But honestly, those DAs, they don't do the stuff that these guys do, okay? They're big, powerful people, big picture people. You know, I prosecute people and deal with victims at a different level. And I can tell you that the District Attorneys Association has received this bill the same time I did. And the time frame in order to try and we can't get 62 DAs in a room to form a consensus as to how to deal with this issue. First of all, 62 DAs may not agree with exactly what the deal is. And I really don't want to speak for the DAs Association, but I can tell you that there is not a consensus, that there is a grave concern about the bill, but the time frame in order to form a uniform response is just not, it's not feasible. We can't do that in 2 weeks.
If the bill passes the way it is right now without any changes, how would you characterize the impact in Ulster County?
Well, it's a wait-and-see situation. I've addressed a few of the things that I'm concerned about. I am sworn to uphold the law, and I obviously will do that. So if these are the changes and these are the ground rules, then that's what we'll do, and we'll do everything we can. We'll do everything we can. The Juvenile Justice Court that they anticipate in this bill, that's in the bill, that is something that I would appear in. That's not a family court. That's a I don't know if we call it a superior court, but that would be a part of the county court or Supreme Court, and my office would be the prosecutor in that court. We would not be the prosecutor in family court. The county attorney does that. I've already said to Mike Hine, anything I can do that you want me to do, I will do. So if they seek assistance in the prosecution of 16 and 17-year-olds, or I guess it's not called prosecution, bite my tongue, the adjudication of 16 and 17-year-olds in family court, if they need resources to deal with that, my office will do that.
Do you know what the county executive's position is on this?
No. He's, of the people that you talk to in this world, there's a few people who know what's going on. He does. He's on this. The probation department's on it. In fact, the I don't know what the name of it is, but there's some county association of counties, like we have an association of DAs, and they sent out the most cogent response to this bill that I have read. There's a summary of the bill and its impacts. It's readable. You can understand it. They're on it. I think they're on it as much on a financial issue than a criminal justice issue. So, you know, they have to be. Well, there's some big financial changes coming your way. The bill says we're going to pay for everything. Heard that before. So, but that's a county exec issue. I'm here just on criminal justice.
Do you suspect that you'll need more DAs if this were to go through?
I don't see that. I mean, it's the same. We've got the same cast of characters, whether the portal is family court or a juvenile justice court or the county court or the justice courts. I'm there. I'm going to take care of that. And there's nothing in the bill that I think that would prohibit me from being involved. But as far as the family court process, that would be a county decision. I'd have to sit down with the county attorney and with Mike and say, how do you want to handle this? But this is what we're here to do. Our office, we deal with this kind of thing, and we will continue to deal with it no matter what changes. You've been very quiet.
Do you suspect, even let's say you don't have more ADAs, were they going to have bigger caseloads or different caseloads?
Well, different caseloads, but I don't, you know what? My goal is that there's not going to be any more crime next year. So, you know, we're trying to reduce, and if this bill, if they got it right and they reduce recidivism, terrific. We'll have a crossword puzzle Friday going on in the office or something, you know? But I'm not anticipating that. Anything else?
You said earlier, I think, that did you say earlier that you prosecuted 100 16 and 17-year-olds in 20?
No, that's across the entire state of New York.
So do you know how many you prosecuted in last year?
That's how many people ended up in prison, not how many were prosecuted, okay? And Mel gave me some numbers. I might have those. Hold on. So in the misdemeanor category for 16 and 17-year-olds in Ulster County, 3.7% of those individuals received non-YO adult adjudications. So 3.7%, and the rest were handled by dismissal or ACDs or whatever it might be. And the numbers, that's a percentage. Hold on a sec. In 2014, there were 173 arrests for misdemeanors and 37 arrests for nonviolent felonies and 14 arrests for violent felonies. Those are arrests.
Among the 16 and 17-year-olds?
Yes. Yes.
And of the 173 arrests for misdemeanors, 3.7% of those received non-YO adult sentences.
Yes. Everyone else either had their record sealed or the case was conditionally resolved.
When you say received non-YO adult,
They pled to a misdemeanor.
they put to a misdemeanor.
Basically, they ended up, 3.7% ended up with a misdemeanor record, which I would point out, under this new statute, they would have the ability to have expunged in the future if they didn't get in any further trouble and et cetera. So pretty low numbers given the magnitude of, of these changes.
Of the 14 violent felonies, do you know what those charges were?
No, I don't, sorry. I didn't hear you.
Is that something maybe you would provide to us afterward, that data?
Oh, the data, yes. As far as the 14, what the charges were, I don't know that I have that information. This is, yeah, this Mel gave me this, sure.
Who's sponsoring this?
I'm sorry?
Who's sponsoring this in the legislature?
I don't know that. Do you know? I think, if I understand correctly, you guys we have a representative from Senator Amador's office and from Assemblyman Lopez's office. So pipe in if you know the answer. I believe that the origin of the bill was from the governor. The governor placed the first bill, thanks. The governor placed the first bill into the budget, which is one of the issues that we have because it gets you a very, an accelerated time frame to deal with it. Then after the governor passed or proposed this bill, I think the Assembly had a separate bill that they've countered. I don't know what's all of the detail. So I guess the answer is this is the governor's bill.
Have you spoken to, obviously, representatives from Amador and Lopez's office, but somebody in Cahill, Seward, all of our local state legislators? What contact have you had?
Okay, so yeah, the answer is I've talked to some, but not all. When I was up in Albany on Monday, I talked to Senator Bonasac in person because he happened to be in his office when I stopped in to say hi. We met with the head of DCJS, Mike Green, and the governor's right-hand guy in criminal justice. His name is Terry O'Leary. They were very courteous. They took the time to talk to us and explain the bill and listen to the comments we had, some of which are the comments I have had here. And I followed that up with a letter to Mr. O'Leary, but I haven't had a chance to send a letter to our representatives, which will happen this afternoon. This all came up kind of quickly.
Is that letter something you can provide to us? Just
Sure, I'd be happy. Yes, yes. I will post the letter I send to our representatives on my the website, and so it's free for anyone to look at.
It's just so that I understand. Currently, and let's take the most, sort of the worst crime, which would be murder. Currently, if a 15-year-old in New York State commits a murder, he is charged as a juvenile, is that correct?
Okay, so murder is a really bad example because it's so complicated.
Okay,
There are,
let's not do that one.
yeah.
Let's do a less complicated.
How about rape in the first
Let's do
degree?
rape in the first
Okay,
degree.
there you go. So, because the murder, there are a lot of, there's a youthful adjudication process and an election to proceed and a lot of kind of stuff, and it's just, it's a harder fact pattern. Your Class B violent felony offenses right now, there are some Class B violent felony offenses, which I can elect to prosecute at the adult level. Doesn't happen much in Ulster County.
Regardless of the age?
Well, no, 15 for some, 14 for some. Generally speaking, if it's not a homicide and you're 15, I don't take the case. The only exception I can offer, when we had that cold case, Malik involved with the little fellow out there, that was actually a 15-year-old. I elected to prosecute that case, but again, that's a homicide. But
even then, they were sentenced as juveniles, right?
The
Barsky was.
Malik.
I don't think he was.
I don't think.
He was already in prison for
Yeah, I think I don't remember. I actually don't remember. But the homicides are a harder process. But right now, almost every 15-year-old that commits a crime goes through the family court system. Tomorrow, if this bill passes, then that would be extended to 16-year-olds and then 17-year-olds. And I want to be as accurate as I can. I say the family court process. They actually anticipate on those very serious crimes a youth part in a superior court, the justice court. So, well, yeah. I think, honestly, Patricia, I don't know the details. I wish I did. I think it's a non-jury part. The part I remember about the legislation is that the judge would be specifically trained. They'd have to go to specialized training to deal with youths who commit crimes. And then there is a dramatically different sentencing structure, but the DA is part of that process. That's what I recall from the statute. All right, so what I want you to do, I want you to print a story so the people out there know that this is an issue, and they may all be in favor of it. Everybody might say, you know what, Holley, I think this is the best thing since sliced bread, and that's fine. It's not for me to say. I just think that people should know what's out there, because this is a very dramatic bill that's kind of under the radar, and I'm hoping that the community that we represent becomes aware of it and gets involved in the process.
I just have one other question. And you say that this is a very dramatic bill that's going to have some real ramifications. but I think my question is if that number of 100 is the number across the state of 16 and or 17-year-olds who are sent to prison,
Right.
Really, what are the ramifications?
Because that's the 16 or 17-year-olds that go to prison. Right now, we are including all of the charges that are all penal law charges for every 16 and 17-year-old. So the numbers are much greater. So all of your misdemeanors, all of your sex offenses, all of your beginning domestic violence cases, all of those matters are now going to be filtered through a different process with really quite different results, sentencing results. Well, and I say quite different. I point out that I'm not sure how different it will be because we're not taking these young offenders and throwing them in prison now. But the potential is there, and I really I don't approve of this idea that we can't talk to a youth that they're picked up. I don't know that that's a good idea. I don't know how that promotes justice. I'm very concerned about the lack of input that victims will have in the process, and extending the YO. Not sure I agree with that.
How does it prevent you guys from talking to the youth? They just said don't talk to them.
Well, they have it's one of these bills. They put a bill in, and there's a lot of nebulous information, and they use terms like reasonable efforts and things like that. And of course, they don't do. We've been doing this for a long time, and the rights of an individual who are charged are really clearly defined. We talk about this is what we litigate all the time. So we have a clearly defined process right now. Well, that clearly defined process becomes muddled with this bill, and it says that in essence, you must make a reasonable effort to find the parent before you can talk to them, and you can't talk to them in anything other than a certain designated facility.
So Just so that I understand, are you saying that right now, if you pick up a 15-year-old on the street?
No, 16-year-old.
16-year-old?
Yeah. These rules, a lot of these rules,
Go up to him without a parent?
yes, yes, not without a lawyer. If the guy says, I want a lawyer, he gets a lawyer. But we can bring a 16 or a 17-year-old who's committed a crime and say, you know, you're charged with a crime. We give them random warnings. We talk to them about, you know, what happened, and they choose to talk to us or not. And this would change that process.
Can I ask an off-topic question?
You may. I may not answer it. We got a lot of people here. I don't know if I want to keep them here standing
Just
around.
one real quick. Holly, are you planning on running for this year for district attorney?
That's a question I'm not going to answer right now.
Are you considering-
You know, I didn't bring these people here for me. I didn't. This is not about me. It's not any kind of campaign. Not about politics. This is really. I'm hoping that you care enough about this issue that you'll print something and get people aware. Thanks. Okay. Thank you very much. Oh, yeah, well, who couldn't? Okay. It's a crazy bill. It's
Can I know you just, like, your throat is probably dry from smoking, but could I get you to just simply and bullet point what